So these are some frequently asked questions related to public hearings under the California Administrative Procedure Act, the APA, that's found in the California Government Code. Now, does a state agency in the executive branch have to hold a public hearing? The answer is no, except that any rulemaking body must conduct a public hearing on a proposed regulation if it's requested to do so by any member of the public. What must occur at a public hearing? Under Government Code Section 11346.8, it requires that if a public hearing is held, that both oral and written statements, arguments, or contentions are to be permitted. However, the agency may impose reasonable time limitations on oral presentations. When must a public hearing be requested if the state agency does not propose one? A public hearing must be held if no later than 15 days prior to the close of the written comment period, any interested person or his or her duly authorized representative submits in writing to the state agency a formal request to hold a public hearing on the proposed regulatory changes. And what does a state agency have to do with public hearing requests? If such a request is made by a member of the public, then the state agency is required to provide notice of the time, date, and location of that public hearing by mailing a notice to every person who's filed a request for notice with the state agency. And finally, what requirements can a state agency impose at a public hearing? Well, the state agency has the authority under the government code at any hearing to administer oaths or affirmations by witnesses. An agency may continue or even postpone a hearing as long as it specifies a time and location as it determines. If a hearing is continued or postponed, the state agency is required to provide notice to the public regarding when that hearing will be either resumed or rescheduled.